statement up. Okay, so we have a difference here, and the difference here is to do with the fact that the common law stuff, common law illegality, is not just where contracts go up against things like torts and breaches of contract and other things that are bad in terms of common law sort of frameworks for what we have in causes of action. It's also interesting, this stuff, in that the common law illegality stuff also stops things which are against public policy. And so I'll talk about this close to the end of the hour with things like contracts that are prejudicial to the institute of marriage. Doesn't, strictly speaking, intersect with anything involving breaches of contract or tort or any other areas of the common law, but nonetheless, it is something that the courts are interested in, enough to render some contracts unenforceable. So, again, starting with the this idea that at common law, the courts still won't let or won't enforce contracts that involve some sort of crimes. Now, where you've got crimes, these days almost all crimes are enshrined into our criminal code. We don't like giving judges the power to just make up criminal offences on their own. They used to, until quite recently, they did. They still had these old school common law crimes. Those have long since gone. In fact, the last one, which is still, I guess you could kind of argue, is still an inherent power of the courts to punish people, is contempt of court. That's arguably still the only crime that a person can commit, which is essentially enshrined in the common law. In practice, though, the criminal code sits on top of it and limits it. You can't go, I think contempt of court, the maximum you can go in prison for is 3 months, I think. Don't quote me on that. Don't try it, by the way, by doing anything. Go in there and swear at the judge. Don't do that. But the idea here is that, look, we don't want people, for public policy reasons, encouraging others to go and commit torts, commit breaches of contract, and obviously to commit crimes. Now, a case near and dear to my heart, well, not really, it's a case from trust law that we've gone over with the trust law students, and I'm going to talk about now is Nelson and Nelson. Because Nelson and Nelson just makes me smile. It's so Australian. Why? Because it was a lady who had a house, and she wanted to buy another house. And to do that, she wanted to get a Defence Force loan. What was the problem? You can't already have a house to get a Defence Force loan. The whole point is it's give you some money in order to buy your first house. So if you already own a house, it seems a little unfair. Anyway, so what did she do? She put the other house in the name of her kids. So the first one. So when we got the second house, put it in the name of the kids. All fine and hunky-dory, right? Then what happens? The kids go, "Thanks, Mum." And she turns around and tries to go, no, I didn't mean, I actually intended for that not. I actually intended for that not to actually be in their name. Let's not be silly here. And one of the things, and again, it's really more a trust case than a contract one, is that she had to go to the court and try and argue that she had this unlawful purpose. She had to put all her cards on the table and say, I actually was trying to get do a dodgy to the federal government in order to get a loan. All right. Now, in the UK, United Kingdom, this doctrine, the clean hands doctrine, is strictly enforced. If you were to try that in the UK, they would laugh you out of court. What do you think you're doing? Of course, you can't adduce evidence of your wrongful behaviour to try and get a discretionary remedy from the courts in equity. It's not going to work. And so everyone thought the case was in Australia too, until Nelson and Nelson. And there the High Court said, oh, how Australian is this? Trying to do something a little bit dodgy in order to achieve some result. Well, okay, we're going to let it go if, and only if, you do equity. You do equity by pleading guilty to that offence, repaying the money, paying the fine, revesting everything. In that situation, we will actually, and I'm not kidding, we'll let this go. We'll actually declare that a trust in this case. So it's not going to go to the daughter. You can rebut what we call the presumption of advancement. So, how does that impact things here? Well, turns out in some situations the courts are actually going to let you enforce an otherwise unlawful contract. In some situations where you repent, your conduct matters. Conduct of the party really matters when doing things involving illegality. Something to leave on the back of your mind. Because we think of contract law as being this abstract thing where we're trying to be two abstract individuals trying to maximize our own utility, and we come to this arrangement, and with the rules for things like misrepresentation, pretty strictly construed, a common law. Statute, Australian consumer law, that gives all sorts of protections, but a common law, caveat emptor, tough luck if you don't carefully go through and check stuff. Unilateral mistake, tough luck applies. Here, it's a little bit more lenient, which is a little surprising. But anyway, some quite cool rules. When I say cool, I think they're cool. We do need to talk about, and that is contracts doing a whole bunch of naughty things. Contracts that are prejudicial to the administration of justice. Bribing a judge to do something and then trying to argue that bribe didn't lead to the result that you've got is clearly not going to go down very well if you have to rock up to courts. But people try it. Similarly, this Wilkinson and Osborne, bribing your local MPs, actually going through and giving them bribes. Now, look, they don't use the word bribe. They use the form, facilitation payment or something along those lines. Nonetheless, the courts, in quite broad strokes, do say, at common law, we will not let you enforce these types of contracts that are trying to undermine our civil structure. They're trying to undermine the courts, undermine the parliament, undermine the executive arm of government. And that's fine. That kind of makes sense. Those cases are pretty old, about 100 years old, a pair of them. And they would still apply today, still do apply today. Andrews and Parker, though, look at the year on that. It's Queensland, so you already know that contracts involving sexual mores, sexual morality, if it's Queensland, Queensland in the 1970s might as well be, Victoria or New Zealand in like the 1930s. But strictly speaking, contracts to promote sexual immorality aren't enforced. I'm going to just get some little caveats involving that. So Andrews and Parker involved a dude, wasn't really that bright. I think he was a parking warden or something along those lines. Parking warden, maybe a lift attendant, something like that. And he was keen on this girl, and she was kind of keen on him, and said, sure, I'll live with you, I'll move in with you, I'll be your mistress, if you put this house in my name. You can see where this is going. And so the guy wasn't that bright, goes through, does this, and then miraculously, a week later or a day later, not very long later, she miraculously makes up with her husband, goes back to the husband, and the husband moves in and kicks this guy. I think Andrews was his name, I think Parker was her name. And so, again, but the courts are looking at things like this, and look, this cohabitation and these contracts in order to achieve these sorts of results, these sorts of arrangements or deals, the courts are going to give it pretty short thrift. But one of the arguments that was advanced in this case was that I love using the archaic language. She was acting like some little hussy and trying to get this gentleman to sign this house over to her, which she had no intention of showing any actual romantic things with him. But, which one? Sorry? Yeah, that's it. Love the house, not the bloke. So a more up-to-date version of this, and look, again, the caveat for this, sexual immorality must actually cause the contract itself to exist. It has to actually exist in relation to this. This case here, Ashton and Pratt. Pratt is, what was his name? Bob? What was the guy who owned Visey Cardboard? Richard Pratt, that's it. The Carlton Football Club president, I believe, at some stage. And so anyway, this so Ms. Ashton went to the New South Wales Supreme Court with a decent amount of money. Why? Because Mr. Pratt had come to an arrangement with her where he would give her a sum of money, $500,000, buy her a house, and set up a trust fund for her children, and give her a stipend for travel at $50,000 a year as well. A whole bunch of stuff, $25 million or whatever the whole thing was, if she would come and be his mistress. All right, what was the problem with this? The problem with this was he died before this could be carried out. And so she goes to the executors and tries to argue, and does not succeed, because the contract hadn't actually existed at that point. No rights had actually happened. And in that situation, you can't rely on a variety of other things, estoppel and other bits and pieces as well. Okay, at common law, contracts to defraud the ATO. And again, we looked at Equisacorp. That was a sort of a statutory framework, clearly, stopping schemes. But contracts, and look, occasionally you see these things, maybe not so much these days, but you used to see sort of newspaper ads, guaranteed tax refund. It's a little bit tricky. Guaranteed tax refund? Not sure how that operates. But certainly the courts for a long time have appreciated the importance of the revenue system. Literally the room that the court sits in is paid for by the taxpayer. The entire system falls out, just completely falls over if we don't have a well-funded government. Systems of government in Australia are very heavily regulated, high government, high level of government intervention, high level of government agencies, high percentage of people employed in the public sector on good wages. And all of this necessitates tax. And so contracts that are, their purpose and aim is to somehow defraud and stop people from paying tax aren't going to be accepted by the courts. They're against public policy at common law. Okay, some more cases involving things happening at wartime. Contracts that infringe foreign laws, by default, are actually not going to fall under this area. So common, when I talk about committing crimes or torts, clearly I'm referring to the state of Queensland and or the Commonwealth of Australia. And strictly speaking, a contract to commit a crime or a tort in another jurisdiction outside of Australia, strictly speaking, that is okay, unless they're one of our friends. So a contract to commit a crime in North Korea, a contract to commit a crime in New Zealand are going to be two quite different things. And the key test is whether or not it makes Australia look bad. So committing crimes inside North Korea might not be bad. Admittedly, if those crimes are trying to feed people who are starving, which is probably a crime in North Korea, I don't know. That in that situation, that's not going to make Australia look bad. Whereas, committing a crime in New Zealand, hypothetically, bombing a Greenpeace boat in the middle of the Auckland or the Waitemata Harbour while it's parked there after protesting your nuclear tests. That sort of stuff is going to be a bad look. Don't do that. And again, that's that Regazzoni case involved. It was a wartime case. So I was going back to something that had happened during the war. And in that situation, it depends whether or not the breach involves one of our allies or one of our enemies, one of a better word, in relation to that. Somerset's case. I don't know if this is in your contract law book, but it's a good piece of information. Somerset's case referred back to an older case called Cartwright's. And the famous phrase that came from that is the air of England is too sweet to sustain or allow, what were they used? Slavery. The air is too sweet for a slave to breathe. That came from Cartwright's case. Cartwright's case involved I believe, a Russian? I think it was a Russian, possibly Romanian slave. And you'll note the ethnicity matters here. Look at the years between Cartwright's and Somerset's. So there you had essentially a white slave in the UK, or the UK, long before it was called the UK, in England. There the court said, at common law, slavery is considered to be abhorrent. You have to pay people. Did that apply to the colonies? Well, the trouble with the common law of England is that the way the common law is supposed to apply is that you take the common law, you take your boxes of all, your books of all your judges, you go to wherever the English go, dump their things off, and you adjust that law to make it applicable to the local surroundings. So while slavery was essentially unlawful in England in the 1500s, carried on being a thing in the colonies. But by the time Somerset's case rolled around, England, or by this stage it was the United Kingdom, it was Great Britain actually by that stage, the crowns had united of Scotland and England, and slavery wasn't a thing. At least it wasn't a thing in England and the United Kingdom. It was still kind of a thing in the colonies. And so Somerset was a black slave who had come from Jamaica and had to the UK, to England, had escaped, got recaptured, and a writ of habeas corpus was issued. There you go, a bit of admin law. And they used this language, they used literally the same phrase from Cartwright's case, and said, look, the fact that this slave is black as opposed to white actually makes no difference in that situation. Don't get me wrong, the arguments were certainly made by the other side in terms of what would happen if we released all of the slaves everywhere? Well, it didn't matter. The courts, in that particular case, Somerset said, no, slavery is not enforceable. You cannot make people work for you without paying them. Those are those two cases. Okay, that's a bit of legal history there too. You probably should know those two cases. Tuck that in the back of your mind. The courts will not enforce contracts prejudicial to the institution of marriage. These sorts of things here, marriage brokering. This is the turn of the 20th century, not the turn of the 21st century. And so there, they thought that was against public policy because it undermined marriage. I would have no idea how something like, what was the one, Ashley Madison? Does that sound familiar? Yep. Prejudicial, it means undermining it. So things that somehow destroy or nullify or undermine, in some way stop or reduce the quality of the institution of marriage. The things that make marriage less prestigious, things that make marriage less important, and somehow remove its esteem from our society. Contracts to do that aren't going to be upheld at common law. Oh, forced marriage is a little bit tricky. Well, forced marriage is unlawful in the statutory regime anyway. And in terms of how things operate, in terms of the common law rules, when people come from countries where forced marriage is a thing and come here, I don't know. I'm not sure. Largely because marriage is an exclusive federal power. And so since 1901, the federal government has had power to legislate over those things. So it doesn't intersect with this part quite so much. It's interesting to know, though, actually. Interesting to know how it works with that. I mean, certainly the hot topic at the moment is, hot topic, sounds terrible when I say that, contemporary slavery is this hot topic. People going in terms of cross borders and the anti-slavery regime, statutory regime that's been passed. And Jamie Fallows just did a big presentation on it this week. Okay. Okay. Baker and Jones and Scott and Avery. These are actually important. These are important for your legal practice. It seems like I've tucked this away in the bottom of all of this waffly stuff talking about marriage. But Scott and Avery clauses are really important. Really, really important. Because you can have a contract that says, before we go to court, we have to go to arbitration or mediation or some mechanism to resolve this. Because you can't put a clause in a contract that says, if you don't like this contract, you can't go to the courts. That is a clause to oust the jurisdiction of the courts, and they are strictly unlawful. The courts can't, by definition, entertain such a clause. They can't. They're like, you're bringing it to a court to interpret a clause that says you can't bring it to the court. It doesn't logically make any sense. But as a very, very important practical consideration, we actually don't want people to go to court. If they can sort their things out themselves, you let them sort their things out themselves before they go to court. And so putting these clauses in, and Scott and Avery is really old, and that's over 150 years old. There it said, a clause in a contract that says we have to go to arbitration before we go to the real court, they will be upheld, usually by the court that a party's appealed to, remitting the matter and saying, no, we're going to stay this matter. By stay is a legal technical term that means leave this matter on hold, just freeze it, push the pause button. That's the technical word, S-T-A-Y, is to stay a matter, is to leave it on hold until something else has happened. So they usually say, we'll stay the matter here until you have gone and got arbitration. Then you can come back. All right, if it's not already resolved. Scott and Avery clauses are valid law, have been valid law for over 150 years. Okay. Oh, the big one. How much time have I got? Enough. One type of clause that we do have to analyze because they're important in commercial practice is what's called a restraint of trade clause. Because when you've got people in certain types of relationships, so employee-employer relationship, when the employee leaves, she or he can take all of the knowledge that they've gained from this employer and go straight to the competition. Is that a problem? Well, it requires something of a balancing act. We want people to rock up. Well, first of all, we want people to employ other people. It's Australia. It's all about jobs, 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 jobs. We want to have lots of employers hiring people, sure. And we don't want people leaving jobs to have to go on the dole because they can't work in that particular area or that profession because they're restricted from doing so under terms of their employment contract. Not only is it not good for the individual, it's not good for society. Highly skilled technical professionals who can't use their skills because they're under a particular contractual clause that says you can't use your skills here is problematic. We want people to be able to use their skills and go elsewhere. And Buckley and Tuddy was it's actually a league case, I believe. Might be league. I'm pretty sure it was rugby league in terms of the whether or not a person playing rugby league can go somewhere else. If you've got a restraint of trade clause from a particular club that says you can't go and play for the other clubs after you leave us, can that be upheld? And so what the courts say there is that it has to be reasonable and can't go any further than protecting the legitimate interests of the employer. Say that again. You can have a restraint of trade clause in an employment contract if it is reasonable and goes no further than protecting the legitimate interests of the employer, and no further. And from a practical perspective, the way these things are structured are usually like this. You cannot work, we'll say, for example, Jordan cannot work as a software developer in Queensland for 10 years after leaving my software business. All right, they'll have a clause that says that. That seems pretty harsh, eh? All right, now, what they'll have under that is the next clause will say, if clause A is held invalid, Jordan is not to work in North Queensland for 5 years as a software developer. And if clause B is ineffective, clause C will say, Jordan is not to work for 3 years as a SQL database designer or some subset of software development, say a Java developer, all right? And then another clause under that saying Jordan is not to work in the city of Townsville for the period of 2 years. Anything involving Java development. And then have another clause and so on until they're finer and finer and finer. Jordan is not to work for 6 months on this particular project, only in postcode 4814, something similar to that. That's how those things can be structured, because the courts can go through and say, unreasonable, yeah, this one will do. That is how those things are structured. Now, make note, when you're selling a business, the gloves are off. Why? Because the price you sell the business for can include that clause as part of the value. And a good example of this is Nordenfeld, Maxim Nordenfeld Guns and Ammunition Co. A restraint of trade clause was put in for an arms seller. There aren't many arms sellers, and there the courts actually held a 25-year exemption on selling weapons was okay. Why? Well, because it was factored into the cost of selling the thing. If you're selling the thing, you get to negotiate what these clauses are. It would be quite different if that was employment, quite different. But essentially, there aren't many arms manufacturers, and if you could just go and carry on selling arms, that would kind of undermine the entire point of selling the business in the first place. There aren't many arms sellers, and so that was held to be okay. And again, it's because you can factor into the price. And with employment contracts, again, trying to work out what things are reasonable, if you're paid a lot of money as part of that, and you do have a restraint of trade clause, the courts will factor that into account as well. You're paid, but it's a little bit trickier with employment though. Usually though, people don't have massive restraint of trade clauses in employment contracts. We should do that a little bit later. We'll talk about specific performance in about 3 weeks' time. Okay, exclusive dealings. Now, that is what we call, I think in New Zealand we call them trade tie-ins. This idea of, we'll set you up with this petrol station and give you a discounted lease and help you with the shop fittings if and only if you buy branded products from us and us only and not any of our competition. Or you deal with us and don't deal with somebody else. It's basically having contractual terms to stop people from essentially assessing and using available suppliers and or customers in the market. Purpose of those, strictly speaking, that kind of lessens competition, and governments and courts for a long time have recognized we don't want to lessen competition. Monopolies are bad, generally. Monopolies are generally bad. By encouraging competition, we encourage creativity, we encourage thrift, we encourage prices to be lowered, to become more competitive with others in the same market, in the same industry. Better competition is really healthy, and exclusive dealing arrangements kind of run up against that. And so Parliament's jumped in here a little bit, and they've said that, look, often these types of arrangements actually require a bit of analysis, and courts are not actually that good at doing this. This is an example of something where the Parliament said, yeah, we could leave it up to the courts, but it's probably better to give people who know what they're doing a bit of statutory power to do some investigations and to actually examine whether types of exclusive dealings are okay and whether other ones go too far. And so they basically give power to the ACCC to go off and check those things. And in some situations, the ACCC will go investigate and say, look, this is okay. Sometimes they say, this is okay if you do X, Y, and Z, but you can talk to the ACCC, say, we want to do this. They examine it, look at it, give you a recommendation and say yay or nay. I have discretionary administrative power to do this. It doesn't fall within the domain of the courts. Okay, so restraint claim, it's actually a pretty important area. I've kind of glossed over it because it's the end of a really difficult lecture for you guys. Your brains are probably mush at this stage. Apologies for that. This is not just my opinion, it's probably the opinion of everyone in this room. This is the hardest subject matter. It's also Steve's opinion as well, who I happen to see on the way over. Very, very much the hardest material. Okay, very last slide. So, we've got some illegality. What happens next? What's going to happen with contracts that are in part or in whole invalid? Now, let's go back to this idea that I had before about the courts of common law not wanting to be the destroyer of bargains. As such, they, if they can, will maintain a contract that is not strictly unlawful by trying to strike things out of it. All right, they can find particular, okay, so an example again might be a contract for the sale of goods that has a clause in it that says the consumer guarantees in the Consumer Guarantees Act don't apply. All right, very, very easy thing to do. All the courts have to do is say, well, actually, Section 64 of the Australian Consumer Law says any clause which purports to exclude these consumer guarantees is going to be invalid. And that's what they do. We will just remove that out. But, and there's a big important but here, removing that clause can't wreck the entire contract. So if, for example, the entire contract was premised on those consumer guarantees not being present. So, for example, I'm supplying goods that are not fit for purpose. I'm supplying tainted meat. Well, you know it's tainted meat. I know it's tainted meat. All right, we're only going to use it for certain purposes. I don't know what you guys go up to in labs. But strictly speaking, the consumer guarantees would apply on that particular transaction, assuming that they did apply. We want to try and exclude that stuff. We can't. And it's going to undermine the entire contract. In which case, the entire contract is going to fall over. The courts won't just remove that clause. It goes to the absolute heart of the contract. If without those consumer guarantees, the other side's going to be liable for absolutely everything. They would need to guarantee that their meat wasn't tainted, and that would render the whole thing pointless. Okay, so what happens when contracts are rendered void? Ab initio, we know what that term means. This is where things, and you reckon it's been hard up to this point. Okay, welcome to see this part. You know, I talked about conduct. The conduct of the parties matters. And so here, the idea is, the starting point, a contract which is void is unenforceable by either party. No party can go to court to enforce their rights on a contract which is rendered void through illegality. If there's naughtiness, we're not going to go near it. That's the starting point. However, we do appreciate that some aspects to this is going to end up to have some really unfair results. And so misrepresentation and fraud in relation to contracts. And in particular, I'm not here talking misrepresentation in terms of inducing parties into the contract, talking misrepresentation about things involving the legality aspects of it. Misrepresenting that certain types of conducts are lawful when they turn out not to be. It can be either misrepresentation or it can be actual fraud. Fraud is where you actually intend to deceive something in order to achieve a personal benefit. I didn't put fraud in there, but that does count as well. And this other part, being not in pari delicto, I've probably said that completely wrong. This is to do with fault. Okay, and in pari means in par. Usually when two sides, starting point with a contract, both sides have come into a contract, it's unlawful, and they're both naughty. They're both naughty. They are in pari delicto. I'm not sure what the delicto is, what that root word means. Delinquent? Probably delinquent. They're both naughty to some extent. And the in pari, they're paired. They're both naughty. If you can prove that you are actually innocent in relation to the unlawfulness, you can go and seek some sort of remedy. Now, I talked earlier about Nelson and Nelson. She was naughty. She'd gone to get that loan from the Commonwealth Defence Housing Organisation in order to do this thing, to buy a second house. She was naughty. And in equity, normally, the clean hands doctrine applies. There the court said, look, we unwind that. We will give you a remedy in equity as a result. And the remedy of restitution is an equitable one. You cannot seek restitution to have money given back to you that's been paid where it leads to the other side being unjustly enriched. You can't do that unless you are not in pari delicto. In other words, you have to prove that you were innocent in regards to the illegality. You either didn't know, you weren't aware of what they were doing, or if you did know, the other side was far more culpable in relation to it than you. So this idea of your conduct matters. It really does. Because by default, you can't enforce rights, you can't, debt can't arise, and you can't get damages. You can't sue for damages for breach an illegal contract by default. You can use a thing, which we'll talk about, I think we should start next week. Yeah, we'll be next week, called quantum meruit. Quantum meruit. Yeah, quantum, Quantum space MER. I always get this wrong. I think it's UIT. The idea is quantum means amount, and merit means, well, merit, amount that you deserve. The idea is that in equity, if you do work in situations where it turns out there's not a contract, then you can seek some form of remedy to get paid for the amount, a low amount, for the amount of work that you've done and the labour and materials you've expended in some situations. That is a remedy in equity, as is restitution. Your conduct matters in regards to unlawful transactions. Okay, and finally, again, being not in pari delicto, in other words, not equally wrong or mistaken into a contract, where a particular statute is actually designed to protect you. An example of that is a statute, something like the Residential Tenancy Act, is designed to protect tenants from unscrupulous landlords. And in situations like the Residential Tenancy Act, having some illegality in terms of the contract, well, it's designed to protect you as the tenant. And which is why if you rock up as a tenant, by the way, has anybody ever been to QCAT for a tenancy matter? I haven't. Oh, you have been. Oh, God, I haven't had to do it in Queensland. I had to do it in Victoria. It was awful. But here I've watched quite a few of them. And I've got to say, if you're as a tenant, if you keep paying your rent, it's literally the only thing you have to do. You keep paying rent, you will win hands down essentially every time. It's crazy. It's absolutely crazy. The courts bend over backwards. Why? Because you are the class of persons this statutory regime is designed to protect. Whether that's a good thing or a bad thing, that's for your local member of parliament. But just that rule in was it Kiriri Cotton, will apply in situations where you've got a statutory framework that's set up, usually to protect the weaker parties in some things, and often, again, involving things like rent control, leasing, and consumer stuff and employment stuff. Okay, I reckon we might leave it there. Pretty mushy, eh? There's a lot of stuff to digest. This area of law actually goes in much, much more depth. I'm not sure how in-depth the Radin and Gooley textbook is, but there's genuinely a lot to it, and a very high fraction of contract law cases that go to the High Court involve some aspect of illegality. Reasons for that? Our society gets more and more complex and more heavily regulated. It becomes easier to break the law because you don't know what all the laws are. So many statutes interact with things that we do right now. All of us are probably breaching some statute in some way right now. Probably. Don't know how. But what that means is that this area of law, this area of contract law, gets more complex, it gets trickier to interpret, and it gets more lucrative for you guys in terms of legal professionals because you may end up being involved with things like this. Because the further this goes from what lay people can do, the better it is for you guys. Anyhow, I'll leave that for you guys, and I'll talk to you soon.